is complicated, an awful lot more complicated than jurisdiction elsewhere, I believe. And so can you just give us a little kind of potted scenario of how the English courts, or the Indian courts even, will garner jurisdiction, and the different jurisdictions between the civil and the religious community, which apply to the civil and religious communities in India. And over to you.
Before we go to business, over 4 decades, family law was a poor country cousin in international law conferences, a graveyard session in the end. But my experience over 2 decades with IAFL is, we have now graduated to a think tank level, and we have done extremely well. This meeting is a proof of the pudding, very aptly baked by John and William, and being roasted by James and Honey. 3 cheers to these people who have landed in a place, Malaysia, this small foot in a graveyard session is the best possible evidence of the case.
Well, everybody's here to hear you, Colonel.
Yes. No, it makes a lot of difference. We all have the same problem. We deal with human beings. We don't deal with property. We don't deal with assets. We deal with human problems. We hear people, we understand people, and all of us try to find solutions out of the box. I do it. Malaysia does it. US does it. Hong Kong does it. It's all turning and twirling around.
But how do the Indian courts do it?
Well, 1.4 billion Indians, 34.50 million non-resident Indians, 3.28 million square kilometers, 29 states, 10 union territories, multicultural religious society, statutory laws of Hindus, Christians, Parsis and Muslims. For me, even going to Kerala or going to Madras or going to Maharashtra is a different jurisdiction. But we exist, we live, we work out. When does the problem come? When a marriage solemnized under personal law, let's say Hindu law, in India is dissolved in the US, Canada, Australia, England, America by irretrievable breakdown. That is the problem. We were just talking of domicile, we were just talking of residence, we were just talking about relocation. Our personal law says you remain a Hindu whether you become a German, whether you become Italian, whether you start living in Iceland, whether you start living in Poland, whether your children are born there. The Hindu law goes with you as a backpack.
And does that apply to the other religious communities as well?
Well, in those communities, the Parsis or the Jews or the Muslims, that may truly not be applicable. But keep in mind that the majority population who have migrated abroad are the Hindus. They have changed their nationality, they have changed their domicile, they have dissolved their marriage there. When you want to test your decree as an enforceable judgment in India on jurisdictional grounds, Section 13 of the Code of Civil Procedure will come in and will ask a question: is it founded on a principle based on Indian law? Was it obtained in accordance with the principles of natural justice? Is it ex parte? The test fails. The decree fails. Because irretrievable breakdown of marriage is not a ground for divorce in India. The marriage is sacramental. Dissolution is by fault grounds or by mutual consent. Third ground of the breakdown is not a recognized ground of divorce. The concept of a contract in the marriage doesn't exist. So anything done abroad on the element of contract by relocation, domicile, status abroad fails. So what we were talking is we have limping marriages. You are divorced abroad but married in India. So if you come and remarry in India, bigamy, dowry, matrimonial cruelty, custody, everything opens. It's a crisis.
You've touched upon a couple, three, I think, really interesting and important points.
Can I just add to
but just one question. I just want to. Does what you are saying also apply to marriages dissolved in accordance with the Special Marriage Act, which is secular, I believe?
See, the point is, it is secular. It is solemnized by a civil ceremony, but the grounds of divorce of the Special Marriage Act are paramaterial to the Hindu Marriage Act, which means there is no irretrievable breakdown. So the moment it is to be tested on the anvil of applicability as an enforceable judgment in India, it fails. Now, let me talk to you about the case which my friend with Hong Kong was. I dealt with that matter as an expert.
Yeah.
Parallel divorces.
You also touched upon the whole issue of marital contracts,
Yes.
which you described as illegal. If you're going to further, because that's incredible to those of us who are drafting international marital agreements. How is an international marital agreement executed by NRIs in, say, Hong Kong or Spain or perhaps that's a bad example, but just elsewhere in the world, going to be treated?
See, if you have solemnized a marriage outside India in accordance with the laws of the jurisdiction in that country, and you have entered into a prenup based on the marriage of that jurisdiction, there's no problem. But if you are going to do a prenup in Hong Kong, England, Australia, Canada, and then do a ceremonial marriage under Hindu law in India, it's an antithesis. It can't work.
But you can do a civil marriage in India.
You can do a civil marriage. Now the only difference is when you do a civil ceremony, when you do a civil marriage, you do not do the religious ceremony. Under the Hindu Marriage Act, performance of ceremony is essential. Registration is optional. I have been married for 35 years. My marriage is not registered. Because acceptance in society is done by taking out a bridal procession, calling different people at different venues. Recognition in society. What is a marriage certificate? Recognition, acceptance. You can go to church or you can go to the registrar's office with just two people. What is proof? Certificate. In India, what is proof of religious marriage? 500 people attending a wedding. Destination wedding. Six events. Elephants, horses, big jing bang and whatnot. Goa, Kerala. So the concept is different.
But are people not doing what they do in France, for example, just popping down to the town hall, having their civil marriage, and then have the big...
Absolutely. This is what happens in the churches in England. You first go to the registrar's office, and then you do a big jing bang in the church, and then you go to the nearest pub. Well, that's a different...
But you're not doing that in India.
See, you do it when you have to go abroad and your spouse needs a visa, because the embassy says, listen, we need a marriage certificate. We don't need pictures of all that jing bang.
That's really fascinating. But
But I just want to.
What about? Can you also deal with succession? Because I just feel that dealing with NRIs that actually what they're really worried about is actually their potentially unrecognised divorce. What about how's that going to impact on succession of their property in their death, for example?
You see, I have gone into the finer things of this. There are a lot of very, very wealthy people who have shifted from India or in England and Canada. You name the country, they're there. when Neil Armstrong went to the moon, he found some Indians there. He said, what did you, how did you come here? They said, well, partition took place in 1947, we relocated. So, we are everywhere. So we bring in the baggage of problems. Now, if your assets are abroad, there's no problem. Whenever there is a wealthy, rich, very well done person, I tell him, listen, drop 2 wills. 1 will in England, America, Canada, wherever, 1 will in India. Execute the wills by succession, avoid natural succession, go under the Indian Succession Act. And by the way, all our laws we have inherited from the British. Indian Succession Act, 1925. Indian Contract Act, 1872. Guardian and Wards Act, 1890. And we are still the same.
Well, like, I think most of
I don't blame you.
Irish law, Malaysian law, Australian law.
James, I'm not taking a dig at you. I know you're Irish.
Well, I live in London and I'm licensed in London. But listen, Anil, can you also comment on totally different, just terms of children? India is not a signatory to the Hague Child Abduction Convention. So can you please summarise India's jurisdiction in relation to children who have been wrongfully removed to India or from India from the countries where they were habitually residents? So what is, put yourself in Hague mode or abduction mode.
See, James, this is a subject I have been dealing with Mr. William Duncan and Hans van Loon, the pivots of the Hague, and now Christopher Bernasconi and Philip Lottie. We have been following up with the Indian government, but the resistance to sign the Hague Convention, taking it as giving away the authority to decide, I think is a misnomer. Now, we have to find a way in the system on how to get over it. I was an amicus for 12 long years in a case in which an aunt had removed her niece to England. And the judge tried everything to get the children back. He even sent a special force, the police and whatnot. Nothing happened. So I gave a report and the court sent it to the government, the law commission. It was recommended. We came out with the committee. There was a judge of the High Court who constituted the committee. I was a part of the committee. We did hearings for 2 years. We came out with a 2-volume report. We gave a bill also. But the government is not doing anything about it. So what do? You have to find a way through the fence. This is where lawyers come in. And I think this is where IAFL helps. And this is where brainstorming, learning from lawyers in different jurisdictions helps. So what do? I have brought in the concept of the best interest of the child, which has been incorporated in Indian statutory law after India acceded to this United Nations Convention on the Rights of the Child. We have signed the CRC. We have incorporated the definition of the best interest of the child, a very wholesome composite definition. I have started citing it in all my matters. How do you enforce a foreign court judgment in India from a foreign jurisdiction? We file what is known as a writ of habeas corpus in the High Court or the Supreme Court, and we seek the return of the child in the parent's patria jurisdiction, means the welfare of the child jurisdiction. My first matter, which I did in 1986, I managed to get the child in court, but on the next day the father fled. The judge gave me a roving writ. It took me 10 years to get the child back. 2026, just before I came, 2 weeks ago, I got 2 children out to the US in 10 days. Change of thought process. You tell the judge, listen, this is a habeas corpus. Please get the Commissioner of Police to ask the erring parent to bring the children. Please appoint a counsellor. Let the counsellor talk to the children. Get their guts out. Once the children are normal, get the parents to a mediator. Spend 3 days in a hotel, just talk to the mediator. Throw all excess baggage out. No relatives, no family. In 3 days, we had a 6-page agreement, and the matter was concluded. No pleadings were filed. Every child custody matter needs to become child-centric jurisprudence dispute resolution. What happens? A child custody matter is converted into a divorce petition, domestic violence, misuse, adultery, extramarital relations. What has it got to do with the children? The child says, I want both father and mother. What is family? Father, F, and a mother, M, I, L, love you. Father and mother, I love you. This is what is family. Once a judge understands this and he puts his foot down, you do it. But what does the judge need? Good assistance. So what is happening in India now? The courts have started understanding that if they focus on the children and they look at the children only, if in a summary jurisdiction on the basis of affidavits without any evidence, the matter can be resolved, we follow the principle of jurisdiction of closest contact. Go back to the jurisdiction of closest contact, which will determine the best interest and welfare of the child. We are only doing a summary process. Go back. If you don't want to go back, the Supreme Court is saying, hand over the children, you can stay.
I have to say that was fascinating. Now we've got, I think, about half an hour left, honey, and we still got to have.
I would give up my time for
Stacey. No, but Anil, you've said so many really interesting things.
Wonder Woman.
We want some questions from the floor, and I think there'll be a few.